6 out of 6, a perfect score. Every possible sign of drunkenness in both eyes. Sounds airtight, but stop right there because you need to know what this test actually is. It is not a breathalyzer, no machine, no number, nothing anyone can go back and double check. It is one man moving his finger, watching your eyeballs twitch, and deciding you are drunk. That is the entire test, which means it lives or dies on one thing. Did he do it right? Hold on.
6 out of 6. A perfect score in both eyes. The deputy said it proved Antonio Morales was drunk. Then a defense attorney handed him the training manual for that exact test and asked him to explain, step by step, how it actually works. The deputy could not answer a single question. Not how fast to move his finger. Not how long to hold it. Not even why the test measures what it claims to measure. The judge was still watching. She hadn't ruled yet.
On January 1st, 2026, Deputy Jeff Carroll of the Burnett County Sheriff's Office in Wisconsin arrested a man for drunk driving. It was New Year's Day. He found the man's SUV stuck in a snowy ditch, smelled alcohol, and ran him through the standard roadside test. The driver passed 2 of them. On the 3rd, Deputy Carroll decided he was impaired and put him in handcuffs. It looked like a routine arrest. It was not, because months later, a defense attorney would put Deputy Carroll on the stand, hand him the training manual for that 3rd test, and ask him to explain how it works. And
by the end of this video, you'll understand how a single eye test can carry an entire DUI arrest, and what happens when an officer can't explain the science behind it. On January 1st, 2026, in Burnett County, Wisconsin, Deputy Jeff Carroll of the Burnett County Sheriff's Office arrested Antonio Morales for operating while intoxicated, his second offense, along with operating with a prohibited alcohol concentration and possession of THC.
And the deputy would not be able to answer a single question. Antonio Morales was charged with operating while intoxicated, his second offense, along with operating with a prohibited alcohol concentration and possession of THC in the Burnett County Circuit Court. His attorney, Daniel Chapman, filed a motion to suppress, arguing that the one test his arrest relied on was performed so badly it should not count. The hearing was held on April 28, 2026, before
the case proceeded in Burnett County Circuit Court. Morales' attorney, Daniel Chapman, filed a motion to suppress, arguing the horizontal gaze nystagmus test underlying the arrest was performed so improperly it shouldn't count as evidence. The suppression hearing was held April 28, 2026, before Judge Melissa Mogan, with Assistant District Attorney Jose Vargas appearing for the state.
Judge Melissa Mogan, with Assistant District Attorney Jose Villard appearing for the state. For over 30 years, I sat on the bench. People treat a field sobriety test like it's hard science. It can be, but it is only ever as good as the officer holding the finger. Watch what happens when someone finally asks him to prove he knows how it works.
Before this arrest, Morales was simply a man driving home late on New Year's Day, roughly 5 miles from where he was staying near County Road D, after his own house had burned down and left him displaced.
Receive any training prior to becoming a police officer?
Yes, I did.
What was that training?
The 720-hour law enforcement academy in Northwood Technical College.
And was any of that training focused on the detection of alcohol?
Yes.
On January 1st of 2026, did you respond to a call about a vehicle in a ditch?
Yes, I did.
After arriving on scene, did you make any observations?
I observed a vehicle in the ditch on the south side of County Road D, like a gray colored kind of SUV type car. It appeared to be occupied by one male. I observed the vehicle was on and running, and the front driver's side tire was still spinning. Immediately after making contact with Mr. Morales, I detected a strong odor of alcohol coming from inside the vehicle and his person. His eyes appeared to be half open and glassy and bloodshot, and his speech was kind of broken and a bit slurred. Yeah, I asked him how much he had to drink. He said it was New Year's, so he had had a couple.
A second OBUI offense in Wisconsin carries mandatory jail time, license revocation, and an ignition interlock requirement, consequences that follow a person for years, not months, and that attach regardless of how the underlying evidence holds up on review. The suppression hearing alone represented months of legal proceedings and attorney's fees for an ordinary man already dealing with the loss of his home. The state's case, as Deputy Carroll testified, began when he responded to a report of a vehicle stuck in a snowy ditch. He found Morales' SUV with one tire still spinning, made contact, and immediately noticed a strong odor of alcohol, glassy and bloodshot eyes, and speech he described as somewhat broken. Morales admitted he'd had couple drinks, it being New Year's. Carroll administered 3 standardized field sobriety tests, the horizontal gaze nystagmus test, the walk and turn, and the one-leg stand. Carroll testified he observed 6 out of 6 possible clues on the eye test, 1 out of 8 clues on the walk and turn, and 0 out of 4 clues on the one-leg stand. Morales declined a preliminary breath test. Carroll placed him under arrest for OBOI based on that testimony.
Couple.
And what field sobriety test did you perform?
The field sobriety tests that were performed were the horizontal gaze nystagmus test, the walk and turn test, and the one-leg stand test.
And did you notice anything through these tests?
Through these tests, I observed enough clues, which led me to believe Mr. Morales was impaired. I observed 6 clues during HGN out of 6 possible clues. I observed 1 possible clue out of 8 during the walk and turn, and I observed 0 possible clues out of 4 during the one-leg stand. I asked him if he would submit to a preliminary breath test, to which he replied no.
What happened after that?
I advised him he'd be placed under arrest for odor.
6 out of 6 sounds airtight. Every possible sign of impairment in both eyes, according to the officer's own account. But most people watching this hearing miss what that number actually means, because the horizontal gaze nystagmus test isn't a machine reading. There's no printout, no number anyone can double, check later. It is one officer moving his finger in front of someone's eyes, watching for involuntary twitching, and deciding what he saw. The entire test lives or dies on whether the officer performed it correctly in exact accordance with his training. This is where the standardized field sobriety testing protocol developed under National Highway Traffic Safety Administration guidelines becomes legally decisive. Courts across the country, including Wisconsin courts applying standards consistent with State v. Zivsic, have held that HGN test results are only admissible and only carry evidentiary weight when the officer administered the test according to its standardized procedure. In plain terms, the test isn't just about what the officer claims he saw, it's about whether he followed the exact protocol that makes the test reliable in the first place. If he didn't, the results aren't just weaker, they may not be admissible at all. That single legal question was the entire target of the cross-examination that followed. Did this deputy actually know how to give the test he built his whole arrest around?
Yes.
There it is, under oath. 2 tests out of 3 passed. 1 clue out of 8 on the walk. 0 out of 4 on the one-leg stand. The deputy just admitted the whole picture of impairment he built on those tests comes down to a single one. Just one, the eye test. And that is the heart of the defense's argument. Strip that test away, they say, and the impairment case falls apart. So everything now hangs on one question. Does this deputy even know how to give the test he leaned on? Watch him try to answer it.
You're looking for specifically 3 clues and whether it applies to each eye, correct?
6 total clues, yes, 3 in each eye.
And what are those 3 clues that you're looking for in each eye?
Chapman's cross-examination began by confirming the basics. 6 total clues, 3 in each eye, lack of smooth pursuit, sustained nystagmus at maximum deviation, and onset prior to 45 degrees. Carroll confirmed he'd been trained specifically on the finger movement pattern required to check for each. Then Chapman asked him to describe, step by step, exactly what he does to check for lack of smooth pursuit. Carroll said he moves his finger at a smooth pace. Asked how fast that pace should be, he said he wasn't sure how to answer. Asked whether his academy training complied with the National Highway Traffic Safety Administration guidelines, Carroll said he couldn't recall.
Well, I am looking at the training materials from the National Highway and Traffic Safety Administration, and I have the document that will be moved into, I'll ask to be marked as Defense Exhibit 1 when I'm done. Deputy Carroll, what training were you provided regarding field sobriety testing?
It would be through the Wisconsin DOJ, what Northwood Tech Academy puts together as a curriculum. I believe all their course material is on WileyNet.
Deputy, are you aware of whether the training you received complies with the National Highway and Safety Transit Association guidelines?
I truthfully can't recall at this moment, no.
And you can't recall how fast you're supposed to move your finger when you're detecting lack of smooth pursuit in the eyes?
I had said before smoothly, but if we're going off of the DHSTA, I can't recall their parameter, no.
Asked how long he's supposed to hold his finger at maximum deviation to check for sustained nystagmus, he couldn't recall that either.
In your opinion, or in your training, do you believe that the speed you move your finger matters?
Yes.
Okay, but you don't know how fast you're supposed to move your finger?
Again, I moved at a smooth speed.
Yes, a smooth speed, but whether that smooth speed took 1 second or 5 seconds, you don't know what's appropriate.
I can't remember the exact time, no.
Okay. Moving on to the second clue you were looking for, sustained nystagmus at maximum deviation. What exactly are you looking for that clue?
Sustained nystagmus at max deviation would be the involuntary movement of the eye when the eye is farthermost to the outer corner of the eye.
Mm-hmm.
So it would be the jerkiness back and forth at that position.
And what does the sustained mean?
Excuse me?
You're looking for sustained nystagmus at maximum deviation. What does sustained mean?
It would be continuous.
Asked why sustained nystagmus at maximum deviation is even a sign of intoxication, Carroll said, "I can't testify to that. I'm not sure."
What is the purpose of looking for sustained nystagmus at maximum deviation?
The purpose of looking for
yes.
sustained nystagmus?
What is the reasoning behind why that is a sign of intoxication?
I can't testify to that. I'm not sure.
So you don't know the reason. You don't know how long you're supposed to pause at maximum deviation, and you don't even know how long you paused for.
I don't know the exact science behind it right now. No.
What were you trained?
Can't remember which course material we were taught on.
Okay. And you know it's supposed to be sustained nystagmus, but you don't know how long to wait for or why. Is that true?
True.
Then Chapman played Carroll's own body camera footage and timed the maximum deviation pass at 15 seconds, roughly half of what the protocol requires to properly observe sustained nystagmus. He rushed it. He skipped the pause the procedure requires. In real-world terms, that timing gap matters enormously. A test administered at double speed doesn't just weaken the officer's credibility, it directly undermines whether the clue he claims to have observed was ever reliably detectable in the first place, since the protocol's timing requirements exist specifically to distinguish genuine nystagmus from an untrained observation. What should have happened differently starts with basic evidence preservation. Before relying on an HGN result as the sole basis for an arrest, the department should have ensured officers could recall and articulate the exact NHTSA standardized procedure under oath, since Wisconsin courts require substantial compliance with that protocol for the results to carry evidentiary weight. The prosecutor, before the suppression hearing, should have prepped Carroll on the specific procedural details defense counsel would likely probe, particularly given that 2 of the 3 field tests had already returned passing results. A properly trained officer would have been able to explain not just that he moved his finger smoothly, but the specific timing and pause requirements built into the protocol for exactly this reason. The cost of that failure landed entirely on Morales, who now faces a pending case that turned on a test his own arresting officer couldn't explain. There is no formal mechanism holding the deputy or his department accountable for inadequate training beyond the suppression ruling itself. No fine, no review, nothing beyond the evidence being potentially excluded from this one case. Chapman's strategy targeted a specific legal element, whether the state could establish, at even a probable, level that the HGN test was administered in substantial compliance with its governing protocol before its results could support the arrest. This matters enormously at a suppression hearing because the standard here isn't guilt beyond a reasonable doubt. It's whether the evidence supporting the arrest itself should even be considered. Most people assume a field sobriety test either shows impairment or it doesn't, as if it were a simple pass-fail measurement like a breathalyzer. That's not how it works. The HGN test is an observational protocol entirely dependent on the administering officer's technique, and an officer who can't explain his own technique undermines the foundation the results are supposed to rest on. The state's position, delivered through Assistant District Attorney Vargas, would argue that Deputy Carroll's overall observations, the odor of alcohol, the glassy eyes, Morales' own admission to drinking, his refusal of the breath test, together establish probable cause independent of any single test's precision. The defense's position was that once the HGN test's reliability collapsed under cross-examination, the state was left leaning almost entirely on subjective, non-verifiable observations that a reasonable officer's training should have prevented from ever anchoring an arrest. The open question Judge Mogan alone had to resolve was whether an improperly administered test could still contribute to the totality of circumstances, or whether its evidentiary value should be excluded from the calculus entirely. Judge Mogan's ruling arrived after she reviewed Carroll's body camera footage herself, frame by frame, alongside the NHTSA training manual submitted into evidence. She found on the record that the HGN test was not performed accurately or properly. This ruling reflects the same substantial compliance principle that governs breath and field sobriety test admissibility nationwide. Courts require standardized testing to actually follow its standardized protocol because departing from that protocol removes the scientific basis the test's reliability depends on in the first place. It's a similar evidentiary gatekeeping function to the one established in Dobbert v. Merrell Dow Pharmaceuticals for expert scientific testimony generally, ensuring that testimony presented as objective measurement actually meets the standard required to be treated as such. This case is not really about one eye test. It is about how much weight the justice system places on a single officer's technique and how rarely that technique gets tested before an arrest rather than months later in a courtroom. Every American who has ever been pulled over knows that a roadside test administered by one person with no second opinion in the moment can become the entire foundation of a criminal charge. Antonio Morales' case remains open, with no final judgment entered, but the video that put his arrest in question exists because one attorney asked the deputy to explain what he'd already sworn to under oath. Next time, we're examining a case where a breathalyzer's own maintenance records became the deciding factor in whether a conviction could stand at all. Was Deputy Carroll's mishandling of the HGN test the result of one officer's individual failure to retain his training, or is it evidence that departments send officers into the field without ever verifying they can actually perform the tests their arrests depend on? And if it's the latter, what would meaningful accountability for that gap actually look like?